So, that's what we're going to talk about today. This overlaps something I've done that I talked before. You can find on YouTube called Abortion and Equal Justice, and what I'm going to talk about today overlaps some with that, but there's a lot of new stuff as well. So, if you like what you hear here, you can go watch that as well. In 1857, the United States Supreme Court, that we've already talked a lot about, issued a decision, its Dred Scott decision, declaring that persons with black skin, whether they were enslaved or free, are denied the rights and privileges of U.S. citizenship. They're denied the rights and privileges of U.S. citizenship. Does that sound like the U.S. Supreme Court was treating white people and people of color, as they called them at the time, that people even use today, treating them the same? Does it sound like they were treating them equally? That there was equal protection or equal justice for them? No, absolutely not. And they may have called them both persons, but were they treating them equally as persons? No, they weren't. They weren't. Well, in that same year in Texas, we had a penal code in 1857 that did something very similar. And there's one part of it that says, of offenses committed by slaves and free persons of color, in part 3. And it says that a slave or free person of color, when tried for a penal offense, is, in law, a person. Right? So, I mean, that sounds good. It sounds good. Like, hey, we got personhood here. That's awesome. Okay? But his personal rights are to be controlled by the provisions of this part of the penal code, still quoting the penal code, 1857, and are subject to rules different from those which would be applied in the case of a free white person. This is literally quoting from the penal code, arising from the peculiar position of these classes of persons in society. Okay, that's a direct quote from the Texas Penal Code in 1857, and it reflects the sentiment of many other states at that time. And that is that, yes, slaves, and not just slaves, but even free persons of color are persons, but they get a completely different system of justice than everybody else. They get a completely different protection than everybody else. It's what I would call personhood in name only. Right? Does that sound like the kind of personhood you want? Where you're called a person, hey, lucky you, but you're not treated like all other persons. No, you're treated different. You get a different system of justice. In fact, one example of that was that in Texas, a slave or a free person of color could be punished if they committed a crime with branding with a hot iron on the left cheek in the shape of the letter C. That's one of the punishments that they could get. That is a direct quote, Article 814 from our penal code in our state. So they get a different system of justice than all other persons. Does that sound like they're being treated equally? Does that sound like they're being treated like persons? No, they're not. Well, we're still doing the same thing today, not with slaves and free persons of color, overtly, but with preborn children. Let me show you what I'm talking about. This is from another talk I've given about life beginning and fertilization. This is a map you can see of our states. And in the green ones, in these states define personhood as beginning at the moment of fertilization. And that's great, right? That sounds great. And they make it homicide to kill them in those states. So we have personhood in those states, including this state that you see up there. But let's move on and see what that really looks like. In those states, and in fact in others that may not call it personhood, they may not call it homicide, they may call it feticide. If you kill a pregnant woman and also cause the death of her preborn child, if you do that intentionally, that's double homicide. Intentionally, double murder. If a woman does it to a preborn child, it's also murder. The law applies equally to both men and women to a point. Unless that preborn child is not just any preborn child, if that preborn child is her preborn child, then it's different. Now, can she kill that preborn child? Yes. in those states, and in fact, every state in the country, she can. She can legally, though not lawfully, as we've already heard, do that. So, in the states, in those states, this is what it looks like. Where that woman is prohibited from killing another man, or another woman, or another born child, or even someone else's preborn child, but not prohibited from killing her own. This is, what I'm showing you here is the goal of the pro-life lobby. And that is to prohibit abortion for everyone except the mother. For everyone to be prohibited from aborting a child except the mother. That is the goal of the pro-life lobby. Just like we heard Abby Johnson say, "Oh, I don't support an abortion. I don't support a bill that punishes the woman." In other words, I don't support a bill that prohibits her from getting an abortion. Because, as we've already heard, you can't prohibit it unless there's also penalties. A prohibition without a penalty is no prohibition at all. Everyone's going to ignore it. What does the pro-choice or pro-abortion side want? They only want really a little bit more. They want a physician to be able to assist the woman in procuring an abortion. But if you narrow it down to just the woman, just the mother, they're really the same. The pro-life lobby wants abortion to be legal for the mother, as does the pro-choice community, the pro-abortion community. The goal of the pro-life lobby is this, and that is for it to be illegal for an abortionist to kill a child, but not for the mother. Even if she hires that abortionist, for there to be no penalty for her. This is the historic position, this historic pro-life position, as that they often come, when you talk about this, they have to say, well, that's not the historic pro-life position. And when they say that, I think they're saying it like that carries some kind of authority. But the way I look at it is, considering we have 61 million dead over the last 46 years, the historic pro-life position may be worthy of some reconsideration. Maybe it hasn't achieved the goal that we all wanted it to have achieved. So it's worthy of some reconsideration. So the fact that it's a historic pro-life position doesn't necessarily mean that it's unimpeachable. In fact, perhaps the fact that something is a historic pro-life position should mean that that's actually what we need to look at the most. What we've been doing the most and what we've been the most unwilling to let go of may be exactly what's got us to where we are today. Maybe it's been our Achilles heel all along. Maybe it's even how we got here in the first place. Going also back to 1857, this is in Texas, and I'm going back to Texas law here particularly because that's what Roe versus Wade is considering. In 1857, we not only had the Dred Scott decision, we not only had laws about free persons of color and slaves getting different protection or different justice, but we also have a prohibition on abortion in the state of Texas. And guess what? The mother was not subject to prosecution. It was not illegal, as the courts, as they interpreted this, it was not illegal for a mother to get an abortion. She could not be prosecuted. Even back 162 years ago, the mother could not be prosecuted. Also, the penalty was far less. It wasn't homicide for someone to commit an abortion. It was only 2 to 5 years penalty if someone committed an abortion. Well, the law remained relatively unchanged until 1973, when the Supreme Court considered that law. The laws were essentially the same. And what I want to propose or submit to you is, what if that fact, the fact that the penalties were lower and the mother was not subject to prosecution, that the law did not apply equally to her or her child, what if that's actually how we got Roe versus Wade in the first place? What if that's what led to Roe versus Wade? I'd like you to listen to and watch this with me. We're going to find out real fast if the audio is working correctly. Oops, so on. Oh, hold on. Hold on. Okay, hold on.
The only legislative history, of course, is that which is found in other states, which has been pointed out before, and Professor Meeks points out again. These statutes were adopted for the mother. Certainly, the Texas courts have referred to the woman as being the victim, and they have never referred to anyone else as being the victim. Times have certainly changed. I think it's important to realize that in Texas, self-abortion is no crime. The woman is guilty of no crime, even though she seeks out the doctor, even though she consents, even though she participates, even though she pays for the procedure. She again is guilty of no crime whatsoever. There is no indication in Honduras versus state, for example, the court ruled that a woman who commits an abortion on herself is guilty of no crime. Again, she being regarded as a victim rather than the perpetrator of the crime. Obviously, in the United States, the offense is unheard of. It is abortion, which carries a significantly lesser offense. As we talked last time, they are not subject in Texas to any kind of criminal prosecution, whether the woman performs self-abortion, whether she goes to a doctor, finds someone who will perform it on her. She is guilty of no crime whatsoever. And yet the state tries to allege that its purpose in this statute was to protect the fetus. If that's true, the fact that the woman is guilty of no crime is not a reasonable kind of, it does not reasonably follow.
That's what the law is way from that.
No, I said that would be what would be involved if the facts are different and the state could prove that there was a person that constituted one.
Well, if it were established that an unborn fetus is a person within the protection of 14th Amendment, you would have almost an impossible case. You would
I would have it very sure.
you'd have to say kind of thing. You'd have to say that this would be the equivalent of having a child born if the mother's father health having a child around, she'd have it killed. Is that correct? Gentlemen, we feel that the concept of a fetus being within the concept of a person within the framework of the United States Constitution and the Texas Constitution is an extremely fundamental thing. You're right about that. You can sit down and review one of your case. You're right. You have had acceptance of ours. Maybe the Texas abortion law presently goes too far in allowing abortion.
All right, you can shut the audio off. Did you hear that? Those were arguments from Roe versus Wade. From 1971 and 1972, because it was argued twice, because the first time the court didn't have all 9 justices. 2 more were appointed in between, so they re-argued it. And you heard the attorney for Roe, Sarah Weddington, repeatedly harp on Texas doesn't, the mother can't be prosecuted. The mother, it's not a crime for her, so clearly it's not murder. Clearly it's not murder. They're not even treating this fetus like a person. So why should you treat it like it's a person? And in fact, as the court even said there at the end, when Texas does say, we believe that the fetus is a person, is a fundamental thing, and the Justice Potter Stewart says, if we accept that, then your current abortion law presently goes too far in allowing abortion. Like, you know what? He's saying, wait, if we accept your premise that the fetus is a person under the 14th Amendment, then your current abortion law, the one you're asking us to uphold, we should strike it down because it allows too many abortions. Because it allows a mother to commit abortion. And because the penalty is far less. And so that's one reason that they didn't strike it down. Or one reason why they did strike it down, but not for not going far enough. But because they said, if you're not going to treat him like a person, we're not going to treat him like a person. And that wasn't just Justice Potter Stewart saying that. That's from the majority opinion in Roe versus Wade. And I'm going to blow this up so you can read this. Quoting from the opinion, the court said, this is 7 of 9 justices agreeing with this statement. When Texas urges that a fetus is entitled to 14th Amendment protection as a person, it faces a dilemma. Neither in Texas nor in any other state are all abortions prohibited. Despite broad prescription, an exception always exists. There are other inconsistencies between 14th Amendment status and the typical abortion statute. It has already been pointed out that in Texas, the woman is not a principal or an accomplice with respect to an abortion upon her. If the fetus is a person, why is a woman not a principal or an accomplice? Still quoting from the court. Further, the penalty for criminal abortion is significantly less than the maximum penalty for murder. If the fetus is a person, may the penalties be different? Did you hear what the court just said?
Yeah.
It just said, if the fetus is a person, why is the woman not a principal or an accomplice? Well, I've got the exact same question. And if the fetus is a person, may the penalties be different? No. No. In other words, you're coming in here saying that they're a person, but you're not acting like it. And actions speak louder than words. So you're not going to treat them like a person, and neither are we. And guess what? We still haven't, for the last 46 years in the pro-life movement, treated them like persons. Because we haven't asked for equal protection or equal justice like we should. Not consistently. And I'm not saying that no one did. I'm just saying the movement as a whole did not. Thankfully, there have been some that have been consistent. Praise God for them. But not as a whole. So why not, though? Why has the pro-life lobby been opposed to this? Why have they consistently said, that's not a historical pro-life position, so we're not going to do it? Well, the first two that you see up here, they argue that, well, the women are too indoctrinated. And they also argue, well, it's not effective. And I deal with those in my other talk, Abortion and Equal Justice, again, you can find on YouTube. So I'll just give a quick summary of them, and then I want to move on to the other one. That, hey, there really are true victims, and they should be prosecuted. So what about this? That we're just too indoctrinated in this culture. Well, I agree we are. We are indoctrinated. But we're not so indoctrinated that we're beyond being responsible for our own actions. I mean, that's insulting. Also, a lot of the fault for that indoctrination, for a belief in our culture that abortion is not murder, a lot of the blame has to be laid at the feet of the pro-life bills that we keep submitting and that we keep passing that say abortion is not murder. It's not just the pro-abortion bills that are saying that abortion is not murder, it's the pro-life bills that are saying that abortion is not murder. So if there is indoctrination in our society, I don't believe it rises to the level that now all of a sudden none of us are responsible for our actions. But if there is, also, we are responsible for that indoctrination. Also, there's another argument that, well, you shouldn't subject the mother to prosecution because that's not effective. Because it's really abortionists that are the problem. And it's harder, because of a rule of criminal procedure, it's harder to prosecute abortionists if mothers are subject to prosecution. Therefore, mothers should not be subject to prosecution. Listen, there is a rule of criminal procedure that does make it a little bit harder. If she is an accomplice to the crime, her testimony has to be corroborated, so it makes it a little bit more difficult. A couple of centuries ago, it made it a lot more difficult because we didn't have the technology or the forensics that we do today. But if this argument were ever true, it's no longer true. It's no longer true. Today, with the technology that we have, the forensic that we have, DNA evidence, all kinds of things, it's no longer true. It's no longer true that it's harder to prosecute abortionists, but it's also no longer true that abortionists are the real problem. As we've seen, more and more and more abortions are going to not involving abortions, chemical abortions. You can go down to your local drugstore and pick up a do-it-yourself abortion kit and go home and have an abortion. That's one reason we just saw in the last couple of days, abortion numbers going down across the country. Well, yeah, that's because you can go do it yourself and don't have to report it. You don't have to report it. So of course numbers are going down because a whole lot of it's happening that's going on unreported. Finally, well, what about women who really are victims? They shouldn't be prosecuted. I agree. But just because there are some women who really are victims doesn't mean that all mothers who abort their children should be considered victims. To me, for women who truly are victims, women who truly are forced into something against their will, that's insulting. We're insulting them, and we're also marginalizing them because we're putting them among all these other mothers who aren't victims, who are willingly doing this to their children. Let's go through these. What different kinds of victims that there truly are, that I'll tell you, there's not a single abolition bill in the country that subjects these mothers to prosecution, those who truly are victims. First what about a woman who's under duress, right? And I have a picture of a gun here because basically a gun is to her head. Someone is threatening her with death or serious bodily injury if she does not get an abortion. Guess what? There's not a bill in the country, a bill of abolition in the country that would subject her to prosecution. And even that doesn't even have to be in the bill because that's already the law in every state. That if someone is forced to commit a crime against their will by threat of serious bodily injury or death, they can't be convicted. They can't be convicted. So we're not asking for that. No, they shouldn't be. They're truly victims. Of course she should not be prosecuted. In fact, in that situation, she has the right to use self-defense against the person who's putting her under duress. But maybe she's not able. Maybe she's not able to use self-defense. But, you know what? A lot of people use this term duress, or you hear a lot of women are coerced into an abortion. And what they really mean by that is not duress, not true duress, that is threat, death, or serious bodily injury. But what they really mean is she's pressured into the abortion. A woman, she's pressured into the abortion. Well, yes. I'm sure there are pressures, outside pressures, that are making her want to get an abortion. That some pressures may even be really strong. Some people in her life may be pressuring her to abort her child by threatening to leave her husband or her boyfriend, threatening to cut off her finances, threatening to kick her out of the house, or threatening her with something else, something short of violence. Now listen, just because you're being pressured to commit a crime doesn't mean that you're excused from committing that crime. Right? Just because a thief may feel outside pressure to go steal doesn't mean that we should exclude thieves from being prosecuted for theft. Just because some thieves may feel some pressure. No, not at all. Not at all. That's not how it works. Everyone feels pressure to do all sorts of bad things all the time. But you don't do them. Why? Because they're wrong. They're wrong. And they should be illegal if they're crimes. And certainly killing a preborn child is. But let's back up for a minute. I don't want to get too complicated here, but think about how absurd it is that, and I put little letters under these just because it helps me. Think how absurd it is that our argument for why one of the arguments for why a mother should be able to abort her child and have no prosecution is because someone's putting pressure on her. Like I said, it's not violence. It's something less than violence. That's why I have a person just speaking to them there. Just consider the absurdity that C is putting pressure on A, and so the answer to that is to let A kill B. Wait, what? That's the pro-life answer to the situation about pressure being on the woman? That sounds absurd. In fact, let's make it just forget the preborn child, just make it a 5-year-old. Make it a 5-year-old child. Do we really think that just because a woman, that someone's putting pressure on her, that we should make it okay for her to kill her 5-year-old child? That's absurd. You know what would be also absurd, but less absurd? If we said she could kill whoever's putting pressure on her. You know what I'm saying? Now, that's also absurd, don't get me wrong. That's absurd too. But isn't that less absurd? Isn't it less absurd that she would have the right to kill someone who's wrongfully putting pressure on her than that she would have the right to kill an innocent person? Isn't that less absurd? Now, they're both absurd. If someone's putting pressure on you that's not violence, you don't have the right to use violence against them, and you shouldn't. But you also don't have a right to use violence against an innocent person to relieve that pressure. But that's where we are. That's the argument that's being made. And it's absurd. We need to reject it. What about situations like ectopic pregnancies, where physicians try to save the lives of both mother and child, but prioritize care based on triage? Should those doctors, should those mothers be prosecuted? Of course not. Again, there's a legal doctrine of what's called necessity that they would not be. And you don't even have to put that into your bills because that's already the law. It's already the law. The law that already applies to everyone and would also apply to these situations. There's also something called mistake of fact. What about a woman who really believed that what she was doing was removing a polyp inside of her? Well, in order to prove that someone has committed a crime, you have to prove two things. You have to prove that they committed a criminal act, that is, they caused the death of somebody, in the case of murder, and you have to prove a criminal mental state, or mens rea, or culpable mental state. Right, that they did it intentionally. Well, if they don't think that it's a person, then it's hard to prove that they intended to cause the death of a person. So, for someone who truly has a reasonable belief or a reasonable mistake of fact, they also could not be prosecuted or defended under existing law. Like, we don't even have to write that into the law. That's already the law in every state. But again, you know how to disabuse someone of that mistake of fact, that what's inside of them is a polyp? Pass a law that says that this is a human being that's treated just like every other human being. And that defense is quickly going to go away. There may be some people who can use it, but very, very few. And if those who do, okay. So again, just because there are true victims, they should not be prosecuted. There's not a single abolition bill in the country that would prosecute them, and under existing law, they would already be, that have defenses to prosecution. So there are some true victims out there. But you know what? Just because there are some victims doesn't mean you treat everyone like they're victims. So now we've dealt with these and discarded these. I want to deal with, really, let's just get down to what are the options? What are the options? And there's really only two options here. I like forcing people into deciding, right? I had a talk, ignore Roe or appease evil. It's one or the other. Well, here, it's one or the other. There's only two choices. If you want to outlaw abortion, if you want to end abortion, you've got two choices. And only one of them actually ends abortion. And like Russell, I'll let you decide which one is that. There's with equal protection, and there's without equal protection. Or the with equal protection, I would call the abolitionist perspective. The without equal protection, I would call the pro-life lobby position. So what does with equal protection look like? Well, everyone is prohibited from killing a preborn person. And there are defenses for victims and things like that apply to everyone. Without equal protection, that is true for everyone except the mother, who has a blanket exclusion from being prosecuted. In other words, she's allowed to kill her preborn child. And some pro-life lobbyists may say, well, no, we're not allowing her to do that. Well, it's a legal principle that whatever is not prohibited is allowed. So if you don't prohibit it, you're allowing it. You may not like to say it like that, but that's the truth. So what does with equal protection look like? What would it look like if we had equal protection where everyone was prohibited from killing a preborn person? What would cases look like? They'd look like other homicides. They'd look like other criminal cases that are going on right now. Right? Law enforcement. A report would be made to law enforcement. They would decide whether to investigate or not, whether they needed a warrant or not, whether if they decided that crime had been committed, whether to arrest or not. Then that would be passed on from there to a prosecutor. And the prosecutor would decide whether or not to prosecute, whether or not to grant immunity. And the granting of immunity, the prosecutor could decide that, yes, I could prosecute this mother, but I really want her to testify against the abortionist. I really want her to testify against the abortionist, so I'm going to make a deal. I'm going to say, if you testify against the abortionist, who is the mass murderer, if you do that, then I'll give you immunity from prosecution. And I would expect that that's actually how most of these cases would go, right? That's how most of these cases would go. Most prosecutors would give mothers immunity from prosecution, so they would not ultimately be prosecuted. But moving on, the prosecutor would then decide what charges should be filed. And if the charges filed would be a felony, which is any homicide, then the prosecutor has to go to a grand jury in most places and ask the grand jury to indict that person, to indict the mother in this case, to indict her. And the grand jury, they get to decide, should we call witnesses? Who should we call? How are we going to decide this? And they can decide, are we going to indict or not? From there, it goes on to a judge who oversees the pretrial proceedings, and then we go on to a trial jury. Again, if it's a felony, you've got 12 people. And they're deciding, are we going to convict? They hear all the evidence from both sides, presented by both sides. An attorney's going to be provided to the mother or whomever gets prosecuted. They're going to decide whether to convict or not, and what they're going to convict of, if anything. And then, if they do convict, they decide what the penalty is going to be. In fact, in some cases, it'd actually be a completely another jury who's going to decide what the penalty is going to be, if there's even going to be a penalty. From there, you can appeal your case. You may appeal it to 3 judges, or it may be appealed to the entire appellate court. You may have up to 18 judges reviewing this. From there to your state's highest criminal court. And from there, even, again, if it's a capital case, you could go to the U.S. Supreme Court. And also, if it's a capital case, you get to go back through all of those appellate courts all over again. Okay? And at the end of all that, your judge holds a key, your governor of your state holds a key to unlock. Your governor can pardon. Even someone who's been convicted and gone through a whole appellate process, your governor can pardon somebody and say, you're free. Or your governor can commute a sentence and reduce it, maybe from capital down to life, or from life down to 20, 10, 5 years, 1 year, 1 day. The governor has the power to do that, to pardon or not, or to commute or not. So this is our entire justice system in these United States. This is what it looks like. It's very, very difficult to prosecute someone. It's very, very difficult to convict someone. Because look at all of these different people who are involved in that. They have to be almost unanimously in agreement about what the conviction is, of what it is, and what the penalty is, what the sentence is. So whenever people, they come to us and they say, you just want to execute women because you want to pass a bill that applies equal protection. First of all, when they say that, I'm going to hold my tongue there. They're not being truthful, or they don't know what they're talking about. Is that a charitable way to say it? Because, no, all we want is a bill that changes the law to get rid of discrimination and that applies equally to everybody. Yeah. It applies equally to protect everybody, and it applies equally for everyone to go through the same system of justice that also has the same protections to prevent unjust convictions. And again, should there be more protections in our system to prevent unjust convictions? Yes. Yes. But just because there aren't doesn't mean that we throw out the whole thing. We work on both at the same time. Our laws should be equal. They should apply equally to everyone. And then we wouldn't just be saying that a preborn person is a person. We would actually be acting like it. We would be treating them like they were equal. So these are the 2 alternatives, coming back to this. I've just walked through what it would look like if we had equal protection in our land, what those cases would look like. And that is that our system of justice would handle those. But what about without equal protection? What does that look like? What does it look like when most people cannot kill preborn children, but the mother can? Well, it looks like this. If one of these people, if any other man or if any other woman did it, they would have to go through the same system of justice that we've already described before they could be convicted. But the mother would not. The mother would not. No matter how, as we have seen since we've come face to face with some people who have been extremely open and vile about desiring to kill their children, some of them even, like, I want to get pregnant just so I can kill my child, even they would be free to continue to do that. Or look at it another way, this system of justice protects everybody else except the preborn child. It does not give them the same protection as it gives everybody else. And here's something to think about. I really want you to focus in here, because this is something to think about. And this is something that I want to encourage you to use when you're discussing this with people who oppose equal protection, when you're speaking with a pro-life lobby. And that's this. You're saying that abortion should be prohibited for everyone but the woman, everyone but the mother, right? Because it is prohibited for women, for other people's preborn child, it's not for her. So for the mother, you're saying that everyone should be prohibited from, performing an abortion or helping with an abortion, that the only person who can have anything to do with an abortion is the mother. And she's allowed to, right? Yes, that's right. Women should not be punished. Okay. What you're saying then is that these people over here, other people in her life, including her doctor, who's now prohibited, right? Because if we outlaw abortion, except for the mother, then now the doctors are also prohibited. The doctors are also prohibited from helping, aiding, and abetting the abortion. The only person under that framework would be the mother who could do an abortion. So you know what's the only kind of abortion that she could perform, that she could do? It's a do-it-yourself abortion. That's the only kind of abortion open to her. The only kind of abortion open to her would be a do-it-yourself abortion, because it's illegal for anyone to help her with an abortion. So what does that leave open? That's right. It leaves open coat hanger abortions. Or she can mix up her own poison for her own child. Well, that would be very dangerous. Well, all abortions are dangerous. But this would be dangerous not just for her child, but for her. But that's what the pro-life lobby tells us that we should want. Look at this. Here, when it comes to the mother, here's what the pro-choice movement wants. They want it to be legal for the mother. What does the pro-life lobby want? They also want it to be legal for the mother. What does the pro-choice lobby want? What does the pro-choice movement want? They want it to be safe for the mother. But we've just looked at what would happen under the goal of the pro-life lobby, and that would be that it would be unsafe for the mother. Right? Because she can't go down to the local clinic, she can't go down to a surgery center, she can't go hire a professional. The only way she can get an abortion is to do it herself. So the pro-life position, it's legal for the mother, but it's unsafe for the mother. Does that make sense? I reject it. I reject it. I don't think abortion should be legal for the mother. And I don't think it should be safe or unsafe for the mother. I believe that abortion should be illegal for everyone so that everyone is safe. Everyone should be safe. We should promote the safety of everyone by making abortion illegal for everyone. So that's the difference. These are your two options. You got to pick one of these. If you want to end abortion, you got to pick one or the other. Is it going to be equal protection or unequal protection? Is it going to be no one can get an abortion, or mothers can abort, but they have to do it alone? Which one of these is the most just? Which one of these is the most logical? Which one of these is the safest for the child? And which one of these is the safest for the mother? It's time to abandon the illogical, historic pro-life position of denying equal protection that helped lead to Roe versus Wade. It was used as an argument for Roe versus Wade in the Roe versus Wade opinion. And for the last 46 years, we've been reinforcing Roe versus Wade because we've been continuing to write bills, to put forward bills that deny equal protection. And when a bill does come up that provides for equal protection, the pro-life leaders, like in my state, go to the New York Times and the Washington Post and call and demonize all of us because we want to go execute women, which is not true. Listen, other people, if you support equal protection, other people, even pro-life people, are going to try to demonize you. But I encourage you to stand strong and say with a loud voice a very simple truth. And that is, no one should have a license to kill a preborn human being. That's really, you can sum up, big equal protection, all these terms, you can sum it all up in one phrase. No one should have a license to kill you. Ask the next pro-life lobbyist person you run into, establishment person you run into, they're like, we oppose punching women. Oh, so do you think that people should have a license to kill other people, other innocent people? No one should have a license to kill a preborn human being. Thank you.